everybody, or afternoon, evening, where you are. Let me just introduce what this session is about. 20 years ago, I think international tax, as we practiced it, was very different from what it is today. Tax planning, even tax evasion, were much more prevalent because people could keep their assets abroad in all sorts of offshore corporate and trust structures and sought to avoid paying tax on the income that those assets generated. And that type of tax planning was fueled by the fact that tax authorities around the world had little or no insight about what assets and income their residents earned in other countries. Now, of course, today, we live in an era of much greater transparency. This type of financial information about people's offshore assets and income is now routinely available to tax authorities around the world. And that process of transparency started in 2000 or thereabouts, when the OECD published a report into the use of companies and trusts based in offshore financial centres. The report suggested that information about the persons who had beneficial ownership of such entities should be exchanged with the countries where those people were resident. And that's how it all started. Information exchange has since expanded over the last 20 years or so into the system of automatic exchanges of various types of information that we have today. Now, this has been a gradual process that has led us to where we are today. It's a mistake to think that this process is concluded. We accept that we now live in a world that has tax transparency, but because the process is ongoing, we sometimes lose sight of the fact that further types of information exchanges are going to emerge over coming years. So in this session, we're going to explore what new types of information might become subject to information exchange over the coming years. So to assist us in this, we have a very distinguished panel. Let me introduce them. We have Anu Anand, who is from the Inland Revenue in New Zealand. She is the Strategy and Intelligence Manager. They're responsible for exchange of information and international engagement functions. She also acts as the New Zealand Competent Authority. She's also a member of the OECD's Automatic Exchange of Information peer review group that oversees effective implementation of common reporting standard around the world. We also have Seon Han from the National Tax Service in Korea. Seon is the leader of the Automatic Exchange of Information team based in Korea's Offshore Compliance Division. She deals with FATCA and CRS issues and also other exchange of information roles, particularly in respect of tax rulings. Also pleased to welcome Professor Masato Ono, who is from Meiji University in Japan, a professor today, but previously Masato worked for the National Tax Agency in Tokyo for over 30 years. Latterly, he was director of the Mutual Agreement Procedure Division, but before that, he also headed the International Operations Division at the NTA. And we also have Barbara Voskamp, who is a partner with Loyens and Lerf, the law firm, based in Singapore. She heads the Singapore office of Loyen and is responsible for the firm's ASEAN practice. Barbara specializes in international tax. She also lectures at the Singapore Management University and is a member of the IFA board in Singapore. We also have on our list K.R. Sekar from Deloitte, India, who is heads the Deloitte private practice in India. Unfortunately, although KR participated in the planning for this session, Due to medical reasons, he's unable to attend and he's on medical leave. So we extend him all our best wishes and prayers for a safe recovery. Okay, so let's start. And before we know where we're going, we have to understand perhaps how we got here. So let's start with a history lesson. Masato, could you just tell us briefly, how did we get to where we are today?
Okay, thank you, Michael. Next slide, please. Okay, thanks. This slide is a brief look back of the history of exchange of information. In 1977, OECD Model Tax Convention Article 26 provided for exchange of information clause. In its commentary, 3 types of exchange of information were mentioned. And paragraph 5 of Article 26 provided that bank account information cannot be an exception. However, several countries made reservations on paragraph 5 because of confidentiality of their country's bank accounts. In or around 2008, some controversies occurred when the United States and Germany found that their taxpayers evaded taxes and concealed their money in foreign bank accounts. After these controversies and under international pressures, reservations on paragraph 5 of those countries were withdrawn. In 2010, the United States, which is still furious, enacted Foreign Account Tax Compliance Act, or FATCA, which required foreign financial institutions to provide information of US citizens' accounts with the US tax authority. Countries reached intergovernmental agreements with the United States, either of Model 1 type or Model 2 type, and under these agreements, automatic exchange of information of financial institutions' accounts started. Then in 2014, the OECD proposed Common Reporting Standards, or CRS, under which countries exchange information of financial accounts of taxpayers automatically and multilaterally. Further, in September 2015, OECD's BEPS final reports were issued, and based on these reports, automatic exchange of unilateral tax rulings and unilateral APAs, and automatic exchange of country-by-country report, or CBCR, started. The final report of Action 12 also recommended mandatory disclosure rules, or MDR. The look back stops here, and European Union's DAX 6 and DAX 7 and the model rules of the OECD and what lies beyond the horizon will be discussed in this panel. Thank you, Michael.
You're on mute, Michael.
Thank you, Masato, and thanks for that reminder. It always happens. And that begs the question, of course, what is next? And that's what we're going to explore. So let's turn to the first item that we have on our list, the mandatory disclosure of aggressive tax planning. And there are 2 things to refer to here. Obviously, there's an OECD initiative as well as an EU initiative. And let's start with Europe. Barbara, can you just tell us where we are on the DAX 6?
Thank you, Michael. And although from Singapore today, I'll give some European perspective on some of the transparency proposals and initiatives. DAX 6, I think by far my least favorite topic, as it imposed all kinds of obligation on intermediaries. But maybe one step back, what is DAX 6 about? It is mostly about European intermediaries and taxpayers who need to report certain cross-border arrangements to the tax authorities. So that leaves 2 questions. What is cross-border and what is a certain arrangement? Cross-border means it's EU member state plus 1 other state. And a certain arrangement is pretty much described in all the different hallmarks, which is an extensive list which I won't describe today. And what was the aim of DAX 6 is more to achieve more transparency and fairness in taxation. And it is aimed to disclose potentially aggressive cross-border tax planning. De facto, intermediaries were appointed as sort of agents of the tax authorities, because I mean, tax advisors, intermediaries, trust corporate service providers were all in it to do reporting to the tax authorities. Well, for now, because it's been recently implemented and the first due date was earlier this year, for now it has led to a massive compliance drill, I'd say, also because there's quite some overkill, I mean, if you'd ask me, in the various hallmarks. But I guess going forward, the question is whether it will lead to a change in behavior. But I'll guess we come to that in due course of this session. Back to you, Michael.
Thank you. And that's the EU. And Masato, what about the OECD? What are they doing?
You're on mute, Masato.
Yes. Sorry. Yes. In 2015, 3 years prior to EU DAX 6, OECD issued the BEPS final reports, and its Action 12 report was a recommendation of mandatory disclosure rules, or MDR. It was not a recommendation of automatic exchange of information of tax schemes like DAX 6, which Barbara hates. The Action 12 report just recommended for introducing the system under which tax promoters should report their tax schemes to the tax authority. This idea basically came from systems of the United Kingdom and the United States. The United Kingdom system is called Disclosure of Tax Avoidance Schemes, or DOTAs. The US system is known as Abusive Tax Shelters and Transactions. Mandatory disclosure rules of BEPS Action 12 report was not a minimum standard, but shown as a best practice. So it is each jurisdiction's choice whether to introduce the system into its domestic legal system. In case of Japan, the BEPS Action 12 report was issued both the Tax Advisory Board of the government and Tax Committee of the ruling parties placed MDR as a subject to be considered in the middle term range. So it can be said that Japan is interested in MDR, but so far it has not legislated the system yet. Thank you.
Thanks, Masato. It's interesting, other countries are thinking of this. Mexico, Argentina have now introduced rules about this, and no doubt other countries will as well. Let's go on to the next area of disclosure, the gig economy. And it's a fascinating word, gig, but let's not go into the derivation of that. But the gig economy, Barbara, why don't you perhaps start with what the EU is doing, and then I'll ask Seon to maybe mention what the OECD is proposing.
Yeah, sure. DAX 7, I guess European Commission thought, I mean, that was a good initiative to appoint outsiders as our agents and reduce our workload. So this is what happens in DAX 7. This is where digital platforms are to do reporting on the sellers and sales sellers of goods and services, and who earn income over their platforms. And then you can think about rental of immovable properties, of goods and different services. And again, this is for both EU and non-EU operators. This is fairly new. It was adopted in March this year, and implementation is supposedly end of 2022, and it would be applicable as of Jan 23. It is slightly different from DAC 6, because where DAC 6 is about switching the light on and tackling aggressive tax planning, DAC 7 actually is about tax evasion and tax fraud. This is about transactions that typically are not reported yet. Well, this comes with a whole range of other issues. For example, I mean, how to deal with all that information on the sellers that the digital platforms need to collect and report, but we'll come to that later, if I'm not wrong, Michael.
So when you mention real estate, I think about Airbnb reporting lessors who lease out property.
No, that's correct. I mean, Airbnb is a perfect example, and I mean, coming to looking at the difficulties of this DAC 7 proposal is, so what if Airbnb is reporting on some owner or of a house who's renting out that property for X weeks or maybe months, a year? Would that information, can that be used for other non-tax purposes? Because maybe it's in violation of a other non-tax rule.
When you talk about services, I think of Uber reporting on the drivers in each jurisdiction.
And eBay. Yeah, so it is those kind of platforms that's the bigger ones, but I mean, the scope is quite narrow, so I mean, it applies to a lot of smaller platforms as well.
Let me turn to Sayon. Sayon, what about the OECD? Because they've also come out with a paper on gig economy.
The OECD initiatives, I believe EU DAC 7 also, can be understood as an outcome of the continued intention of the OECD to expand tax transparency in digital economy. Both regimes are about contriving mechanisms that require digital platforms like Airbnb or Uber to report relevant information on tax authorities and support tax authorities to exchange the gathered information on a regular basis. When you try to understand both initiatives, it is helpful to keep in mind that both regimes are close relative to the CRS in terms of both the mechanics and the makeup of reportable information. To share some of the major progress that have been made by OECD on this matter, it was in July 2020 that OECD released a global tax reporting framework, which we shortly call MRDP. And it was in February 2021 that OECD Working Party 10 approved the Multilateral Competent Authority Agreement on this matter, the DPI-MCAA, which will function as a legal framework for AEOI pursuant to the MRDP. OECD and EU model are pretty much alike, but EU model is much wider in terms of the scope and business affected. For example, at current stage, reportable activities only include the rental of immovable property and the provision of professional services under OECD initiatives. But taking into account DAC 7 developments, OECD is now working on the optional module for expanding the scope. For now, it isn't clear how many member jurisdictions would actually come in to sign DPI-MCAA, but compliance burden would be inevitably laid on affected companies. So those companies should assess what changes to their processes and technology might be needed to enable reporting in the near future. Back to you, Michael.
You're on mute again, Michael.
Yes, thank you, Sayon. That was very helpful. And Masato, I think your jurisdiction, Japan, has actually legislated on this issue. Well, what does the Japanese law say?
Okay, thank you, Michael. In 2019, Japan legislated an article to obtain information from internet platform operators. Before this legislation, the tax authority could obtain information, but only if it specified the name and address of a platform user. But under this new article, the tax authority can order platform operators to provide the name, address, and TIN number of platform users who meet specific conditions. However, please note that under this article, information cannot be provided automatically, but only under the order issued by the tax authority. Thank you.
I see. Thank you. Thanks, Masato. Let's turn to probably what is a really exciting topic, this whole issue of cryptocurrencies and the reporting of those. Anu, can I ask you to start on this with the OECD and what are the issues here? Do you want to lead us through this slide?
Thank you, Michael, and good morning, good afternoon, everyone. I guess it is, as you say, Michael, it is a very interesting area. In terms of crypto, we have seen some really major developments recently. The crypto markets have developed so quickly over the recent years that crypto assets are now actually recognized as mainstream investment portfolios, which is, I guess, a good thing and a bad thing. I mean, the real growth in crypto exchanges and custodians has also comes with a risk, and I speak from a very specific tax authority perspective, so there's a bit of bias in there. The gains from crypto investment and what that means from trading and not being returned from tax purposes. So that definitely is quite a catch for us in terms of a priority of what we monitor. The risk, and it's not just for us, the risk also has caught the eye of the G20 finance ministers. And when they put this on their agenda, it became very clear that it had to go onto the OECD agenda to look into the matter of obtaining more information on crypto assets and exchanging that data automatically. But before I go into any more detail about what the OECD is doing, there's some really interesting work that's even happening at the EU. And I might turn to Barbara to speak on that from an EU's perspective.
So after DAC 6.7, we're currently in DAC 8, which is still in public consultation phase. DAC 8 is about reporting obligations on crypto assets and service providers, which is, I mean, pretty much like the DAC 7 reporting for online platforms. At this point, there's a set of questions out there asking industry to give input. The aim is obviously, as you point out, exactly the same, Anu. It is to have a coordinated approach within the EU and to avoid underreporting and non-reporting. They have an ambitious agenda there. But the consultation is out there now, and hopefully there will be more known by the end of this year.
But by the way, I know we're throwing around acronyms, but the DAC, I believe that stands for Directive of Administrative Compliance. Is that correct, Barbara?
I think it's administrative. Is it compliance or coordination?
Cooperation.
Honestly, I wouldn't know. That is hilarious, right?
No, it's funny. We throw around.
Directive
for
administrative cooperation.
Cooperation, right? I was right. Thank you.
No, sorry. Do you want to just continue with the OECD initiative?
Sure, Michael, thank you. I guess just like Barbara said, from a level playing field perspective, the OECD has also recognized that it's important to get crypto investment trading data in the same kind of fair field as all other financial investment data that gets exchanged in the spirit of transparency. Where the OECD is at with this work, I think the likely direction is going to be a new set of rules. It will sit outside the common reporting standard, and this is because the United States is a very big part of the crypto marketplace, and the US sits outside the common reporting standard because they have their own initiative, the FATCA. which is why there has to be a new set of rules developed, because without the US involved in this exchange, it would not be as effective at all. It will probably be crypto exchanges that will be targeted for data from between crypto to crypto, and also crypto to fiat currency trading and investment. The FATF has carried out a lot of work on virtual assets. So the OECD is quite good that way. They will be leveraging off the work that's already done in the FATF area rather than reinventing the wheel. So that'll be helpful for us. The initiative is 2 to 3 years away, which is quite soon in OECD time zones. But from an implementation perspective, I think it'll follow and the lead and speed of the EU DAC 8 initiative. So watch this space.
Thank you, Anu. That's really interesting. Barbara, can I come back to you? We talk about EU initiatives, and we also are talking about the OECD. And the OECD, I get that because that's global. The EU is Europe. Why should we be concerned about what the EU does? And how do the EU initiatives interrelate with OECD? Are they totally separate, or are they in tandem?
Well, there's two things. I mean, no, we don't need to be concerned about what is the EU initiative, but I think it is interesting to monitor what EU is doing from a maybe blueprint perspective. Is this something to be expected in the Asian context? But also, I mean, since the EU adopts like a pretty broad framework that these directives and these regs and rules apply for whoever does business or interacts with the EU. So whenever a member state is involved, I mean, that immediately triggers like the full EU framework. So from a practical point, it is relevant to monitor what is happening there. From a more academic point of view, I guess you can sort of monitor and watch it and assess whether bits and pieces will be copied to this part of the region. Although, as we all know, there's like a high level of distrust within the EU community. I mean, how's that going to pan out in the ASEAN Asian context? But some of those frameworks, I mean, the exchange of information on the regional base make a lot of sense.
And Anu, I mean, I always think of you as approaching this more from an OECD perspective. How do you see this relationship?
It's a very interesting question, Michael. Thank you. And I'll probably build a little bit more even on Barbara's perspective, just from a different angle, though, from a non-EU country perspective, as to how we see it too, from a different lens. So, I mean, I think from how do they interrelate, the OECD Secretariat and EU tax folk, I think they work really well together. We do appreciate the synergies that they try and create so that there is a level playing field across the globe. Of course, we all know that there's not always 100% agreement on everything, but we can see that there's cooperation as much as possible. I guess from an automatic exchanges perspective, as Barbara already said, there is so much focus on that transparency within the EU perspective. For us who sit outside the EU, the other angle we also see is the emphasis on tax transparency. The EU has also produced a blacklist of non-cooperative jurisdictions. And that's very interesting from a non-EU member country. And I think that would be quite relevant for the Asian jurisdictions as much as it is for the Asia Pacific sector. And so there's a lot of encouragement for member countries to actually have countermeasures against those particular jurisdictions who don't actually comply, who are not cooperating. And over time, we can see this could be a concern even from a funding perspective. So that's definitely from a non-EU member how we see that. In terms of other relevance for Asian jurisdictions, I think for the OECD, for most countries who have signed up to the automatic exchange of information, they have obligations that they need to implement and monitor and successfully comply with all the common reporting standard requirements. So that's at the automatic exchange level. And most Asian jurisdictions are also members of what we call the inclusive framework within the OECD. And if you're part of the inclusive framework, you have other obligations like meeting the BEPS minimum standards. There are 4 minimum standards, but I guess the key 2 transparency related ones are the exchange of cross-border tax rulings and also country by country reporting. So there is a lot of relevance in terms of these major bodies and how they impact wider on the rest of the world and definitely Asia. Thank you.
Thank you, Anu. Okay, let's get away from the OECD for a moment and talk about another body that doesn't seem to get much publicity in this realm, the Financial Action Task Force, which operates in the same building as the OECD in Paris, but its focus is not tax, its focus is anti-money laundering. And one of the initiatives that that's been pushed by the FATF is to encourage, force, mandate, whatever term you want to use, countries to maintain registers of ultimate beneficial owners of companies and real estate, companies and trusts. And I think in Europe, this has taken off because the EU is also behind this initiative. But we're also seeing these registers popping up around the world as peer reviews on anti-money laundering highlight this deficiency where it exists, and that forces countries to adopt these registers. Barbara, again, because the EU is also a prime driver, do you just want to explain the concept of the register, and then we'll take the discussion from there?
Yeah, so again, we have a directive on this that entered into force in September 2020. Maybe one side note, which is good to keep in mind when I'm talking about directives in the European context, that is sort of instructions to all member states to implement it into domestic law. That is something that is easily forgotten, because I mean, when you're looking at the actual framework, you need to look at the domestic legislation in each and every member state. But that's just as a side remark. I mean, the directive is like the overarching framework, and as of 2020, all member states were supposed to keep an accurate and up-to-date registers of all the ultimate beneficial owners. Basically, that was split into 2 different registers. One was for corporate and other legal entities, and the other one is for trusts. So within the union, you see a sort of a division there. I mean, not so much for the corporate and other legal entities, because those are always accessible to the general public. For the trust registers, that can be persons with legitimate interests. They always need to be granted access, but for some jurisdictions, amongst others, my home jurisdiction, the Netherlands, we have our trust register is like publicly available as well. So I mean, you see that the directive sets the minimum standard, and then local governments can, deviate from that. What is good to notice is that even for the not publicly available information, that is still accessible to the competent authorities. And one other good thing to keep on your radar is that, especially for Asian families, I guess this is a question that pops up, frequently, is can we structure around the UBO registers? Well, we can, but as soon as we do, that is a reportable, that can be seen as a reportable arrangement under the mandatory disclosure under DAC 6, as I just discussed. So that is two things to keep on your radar. The third thing that I'd like to mention is that obviously it's all very young regulation, and so there's not a lot of experience how certain things pan out. But for this one in particular, there are certain exemptions. That is if there's a risk of kidnapping or blackmail, and how that pans out in practice. That is still a bit of a question mark, and especially for some of the families here living in a different environment than what that's Northern Europe. That may be very relevant to see how that pans out in crystallizes in practice.
And that's really interesting. And we also mentioned there real estate, which is not an EU initiative, but I noticed the UK is concerned about having identification details of people who ultimately own real estate in the UK. And there is a register in the UK that ultimate owners are obliged to file their details on. The big question with all of this, unlike many of the OECD initiatives, none of these details in the registers are automatically exchanged. So the register may or may not be public, particularly in the case of trusts, it may be private. For companies, it's public. So a tax authority can access the register details in other jurisdictions. But there's nothing that automatically compels a jurisdiction to provide details automatically to the countries where those ultimate beneficial owners are located. And I wondered why that is so. And the only thing I can think of is this is not an OECD initiative. The emphasis on this is anti-money laundering. And so it doesn't necessitate the same degree of automatic exchange. But I do wonder whether in future the facilities exist, will we ultimately impose automatic exchange of information requirements? Who knows? And there are also finally issues as to whether it's right that this information should be publicly available as opposed to just being available to government authorities and others with a legitimate interest. And maybe we'll deal with that topic when we get to privacy later. Okay, let's turn to question 7. I think this is the really interesting topic for many of us. Other possible developments, and I'm going to return to Anu, the common reporting standard. It requires exchange of some information, but could be a lot of other information being exchanged. What do we see as potentially happening with expanding common reporting standard?
Thank you, Michael. Yep, that is actually a very topical question at the moment. The OECD is in its 12 months into reviewing the common reporting standard already. We were working on the review last year, but because of COVID, a lot of things had to take a bit of a backseat or slow down. There was only so many discussions you can have virtually and move them as fast as possible. It is from the work that's happened to date, it is unlikely that anything is going to get extended in the immediate future. At the moment, the review of the common reporting standard looks like there's going to be some fine-tuning and tweaking of the current standard based on everything we've learned in the last 3 years of the exchanges we've done. Longer term, there is a view that the CRS as a concept and a model has been very effective to achieve international third-party reporting. And it does, there's a lot of studies around the world that show that it does, just the third-party reporting does deter a lot of tax evasion. So, for example, the deterrent effect, some studies have shown more than a 50% increase in compliance purely on the awareness of third-party reporting. Not even tax administrations not even having to do a lot. Of course, that effect can only last if there is visibility that there is some activity happening and the information is being used. So there's always that credibility there that needs to happen. But in terms of the expansion of the CRS, where we think the next place it'll go, and something that you were just talking about, Michael, and Barbara, is real estate. There is a lot of real estate information that gets exchanged right now between tax authorities, but not in a structured way. It's whatever's available between tax authorities where they can exchange it. I know New Zealand exchanges with more than 15 countries, land and property data, which is quite helpful both ways. But through the Common Reporting Standard and the what we call the Common Transmission System that the OECD has created, which is a pipeline to exchange information, they are looking at that the next cab off the rank might be exchanging real estate information, which will be quite helpful. Thank you.
Okay, thank you. Sion, allow me to turn to you. I know the OECD is very concerned with all these passport schemes and residence visa schemes, etc. What do you see as happening on that front?
Okay, Michael. Oh, do you see the echo here? Oh, okay.
Yes, there is an echo.
How about now? Is it better?
Oh, that's better. Yes, thank you.
The topic that I want to share with you here is actually closely related to the second agenda of our session, which was mandatory disclosure rules. As addressed in our MDR session, and tax authorities want to share information with regards to CRS avoidance schemes. Despite the importance and necessity of MDR, there are certain limitations that might hamper desired effects to be realized. As you're aware, MDR requires any person that is an intermediary in respect of an arrangement which has the hallmarks of APAC, offshore tax evasion, to disclose certain information on that arrangement. But it may be unlikely that those who engage in the role of designing, marketing, implementing, or organizing such arrangements will come to make a report on the arrangements. In addition, MDR do not require the intermediary to disclose information that is subject to obligatory professional secrecy rules. AEOI on newly acquired citizenship or residency by foreign individuals can be a powerful measure to prevent CRS circumvention and offshore tax evasions. It is true that citizenship or residency programs does not always lead to offshore tax evasion. However, it is also true that those programs can easily be used as a tool to hide one's true residency. AEOI on citizenship or residency has advantage over other AEOIs in that it does not have compliance issue of private sectors like banks and intermediaries, because governments already has the information within their government, which means there is no need to ask for private sector's cooperation to collect information. This AEOI model may not be one fit for all measure, but it could be a good supplement for MDR. Thank you, Michael, back to you.
Thanks, Sion. Yes, interesting. I hadn't thought about that non-intermediary point. Helpful. We also have the issue of credit card transactions. And look, I'm being a bit mischievous when I put that in. There's nothing I'm aware of that is suggesting there's going to be automatic exchange of information about credit card transactions. But I just throw in and think about computer facilities exist. If I go overseas and use my credit card in another country, there's no reason why that information couldn't be captured and transmitted back to my home jurisdiction's tax authority, even in real time. So it just makes you think that when the technology exists to do something, I just sense sometimes there's a natural inclinations of governments to say, why not do it if we can? So, but that's something to think about. I want to now go on to a topic that I think often gets ignored in this debate about exchange of information. And this is the issue about privacy. To what extent should we be concerned about privacy rights? To what extent does automatic exchange of information violate what we would regard as legitimate privacy concerns. And of course, in some jurisdictions, like in the EU, for example, but even in Hong Kong, there are actually limitations, I'll call them constitutional limitations, on governments infringing on privacy rights. And does that mean that automatic exchange of information sometimes goes too far and can be challenged? So I'll throw out the question, but Masato, can I start with you? Because I know you were involved in an IFA report at one of the congresses back, I think, in 2015 on taxpayer rights. Do you want to start off this discussion?
Oh, yeah, thank you, Michael. There has, next slide, please. Okay, thank you. There has always been a tension between tax authorities who want to obtain information and taxpayers and third parties who want to protect their privacy. So we should be concerned about this, regardless of which side we are on. Protection of taxpayers' rights was discussed in 2015 IFA Basel Congress. And with regard to international information exchange, general reporters of Basel Congress, Mr. Philip Baker and Professor Pascale Pistone proposed 12 recommendations. Slide 15 shows these recommendations. These recommendations seems to focus mainly on procedural aspects, but of course, as a backdrop, there were concerns about taxpayers' privacy. But the question is to what extent the privacy should be protected and to what information should be obtained. So could you go to next slide? Oh, thank you. I just want to quickly introduce one Japanese case regarding exchange of information. The taxpayer, in this case, taxpayer is a resident of Japan, and the taxpayer and his son own several companies in Singapore and Netherlands, and they made several complicated cross-border transactions. Then the Japanese tax authority requested information to Singapore and Netherlands. The taxpayer's son and related companies challenged the information requests and sought monetary compensation. Next slide, please. Thank you. The Tokyo District Court dismissed these challenges, saying that two information requests did not infringe the plaintiff's right, but suggested the possibility of monetary compensation if the requested information were not foreseeably relevant. But finally, the court rejected the plaintiff's claim, judging that the requested information was foreseeably relevant. Okay, this is just an introduction, this explanation of the case. Thank you.
Thanks, Masato. But Barbara, in the EU, because I always think of the EU as probably having one of the most advanced privacy protection regimes in the EU Charter, is there scope to challenge any of this automatic exchange of information on privacy grounds, do you think?
Well, I think it's mostly about making sure that it is GDPR compliant.
Yes.
And that is easier said than done. But I mean, in all the proposals, I mean, it's emphasized that whatever is exchanged and submitted should be compliant with the GDPR framework. Right. Now you're going to ask me what GDPR stands for.
Global Data Protection.
There you go.
There you go. And in fact, there's a challenge going on in Europe at the moment before the EU, where someone through Ireland has launched a challenge to FATCA. And the challenge is based on the fact that the US, where this data is going, does not have sufficient data protection so that are consistent with European standards. And I don't know where that has got to, but that's going to be a very interesting decision. assuming it does go to litigation. So we will see what happens.
Yeah.
All right, let's turn to this one. I'm going to throw this slide over to Seon and Anu. I've put two questions together. I mean, look, we have all this information being exchanged. Just CRS information is an enormous amount of data. So the first part of the question is, how are your countries reacting to this? Is it seen as a good thing? Is it seen as a nuisance? Are they coping with the information they're receiving? And what do your tax administrations actually do with this huge volume of data that they are receiving? So, Seon, do you want to start, and then we'll turn over to Anu?
Okay, Michael. Straight to the point. There's no new legislative developments in Korea regarding MDR or sharing and gig economy at this moment in time. But with regards to crypto assets, new crypto asset rules came into effect from March this year in Korea, requiring crypto asset businesses to take responsibility of CDD, STR, and CTR just like traditional financial institutions. Plus, crypto asset businesses should report information about their customers and their transaction details on a regular basis. As such, since Korea has already built up the foundation for internal information collection, it is likely that Korea will join AEOI on this field as soon as possible. Moving on to the next question, how Korea is using CRS information. I'm happy to give you some examples. Firstly, the NTS built into IT system whereby exchanged information are shared with audit teams so that they may actively use the information in their investigation into financial accounts. The NTS also cross-checked the list of top delinquent taxpayers whose taxes in arrears amount to a certain level or more with the information obtained through CRS. We use these results in finding foreign assets of top delinquent taxpayers hidden abroad. Plus, last year, we provided CRS dividends and interest data as a reference material with taxpayers when taxpayers file their tax returns through online. Well, basically, these are a few examples of where and how we use the CRS data. Korea is still in process of developing additional ways to use this to make the best of CRS.
Thank you, Seon. Anu, do you want to give us your perspective? You're on mute.
Apologies for that. Thank you, Michael. Quite similar to Korea, I guess New Zealand also supports all the international standards. We have already implemented country-by-country reporting and the exchange of cross-border rulings and unilateral APAs. We've been we've embedded CRS and FATCA reporting for the last few years, so we would see that as a slightly more mature area for us. We've already seen the benefits of the increased transparency amongst our multinationals and high-income individuals, where we've seen a lot more reporting through just from the awareness of the exchanges that we've had. Before we started to exchange the information we were 2018 adopters for CRS. We actually had a nudge and a marketing campaign to let people know that this initiative was going to kick off. And we observed, especially with our high wealth individuals, we specifically wrote to them and said, this is your time if you want to come forward and let us know about your offshore investments. So we thought that was quite a successful initiative for us. We do have a very different culture, one being quite far away, a small island in the corner of the world. And secondly, if you're aware of our property market and the fact that we don't have a capital gains tax, New Zealanders do prefer to invest onshore rather than offshore. So we don't have the same kind of billions of dollars coming back to New Zealand through CRS and FATCA as some other jurisdictions might experience, because we've put it all in property in New Zealand, which has created other interesting challenges for us. Also just touching on FATF, we have actually just recently been evaluated by the FATF on a lot of these areas also, and we have come out as one of the more effective countries. I think we got the 6th most effective country rating. We do have some deficiencies in our laws, and beneficial ownership is also a challenge for us because we don't have the same kind of registers that the panel was talking about earlier, but that's something for us to work on in terms of government priorities, where we go with that. And I guess just another thing I would talk about, from not just from the New Zealand perspective, but also a role that I play in the OECD, which is called the Automatic Exchange of Information Peer Review Group. And that's the global forum. OECD set up that body in 2019, who was responsible for overseeing a level playing field implementation of the Common Reporting Standard. And at the moment, all jurisdictions, which is more than 100 countries, are undergoing a peer review. They're being reviewed on their implementation, their confidentiality and data safeguards, their effectiveness and their exchange and the use of information. So there is quite a good governance body. The body that I'm part of, that's got 34 countries members in there who actually play a really critical role in making sure there's a level playing field. And it's really promising to watch all the jurisdictions who have come forward and actually implemented these initiatives and the benefits they're reaping from it, which is quite important from a global perspective, because there is a lot of scrutiny on the billions of dollars that have been spent on actually implementing these initiatives around the world. So it is quite good, and there will be a report that will be issued at the end of 2022, an AOI implementation report that will show how each country has gone in terms of their maturity of their implementation. Thank you.
Do you sometimes find some jurisdictions just get so much information they don't know what to do with it, or they can't cope with it, or have they all been pretty successful in utilizing it efficiently?
I think, Michael, the answer is probably yes. The challenge is that everyone's got their own current situations and priorities. And the exchanges started in 2017 and 18. So first year was pretty much trial for everyone, just to get the systems up and running. And then we got COVID. So it is time will tell, but a lot of countries are using the information. And part of the governance and the review of implementation is what we call peer feedback. So I know New Zealand definitely gets feedback from some countries who tell us, here's some information we thought we would receive, we haven't, tell us more about it, which is a great indicator of that they're very mature in their use of information and the reporting that they get. So there's pockets, as you would expect, across more than 100 jurisdictions.
Thank you, Anu. And let's go to the final question. And this is the potential impact on automatic exchange of information of things like regional groupings, like the China Oecd Initiative, BRITACOM, I think it's called, Skigata, etc. I don't pretend to have much knowledge of this, but Anu and Seon, can I leave this for you to explain what you see as the issue here? Anu, do you want to start?
Sure. I guess the work undertaken by the members of these groups pretty much does leverage off everything that the government, the international standard setting bodies use. These groups are not ones that go and create their own kind of agenda or standards. So they leverage off pretty much the OECD standards. BRITACOM definitely, it's quite a large membership, but what they're doing is they're trying to create a body which can promote the OECD initiatives and standards that already exist, and maybe at a more regional and cultural level. They don't set any different rules, and the OECD is usually present at most of the meetings and forums that they run, whether it's BRITACOM or SAGATA. I think what I've seen as the most beneficial aspect of BRITACOM and SAGATA is they're big on capacity building. So what they do is there's a good kind of facilitation body which understands what the international standards are, understands the regional capabilities and capacities, and tries to bridge that gap. So New Zealand is a member of SAGATA and an observer at BRITACOM, and our role is quite intensive in terms of providing capacity building. We would run training sessions based on the standards and the needs of the members of these groups. So I think while they're seen differently, they are actually quite valuable in terms of bringing that regional perspective also.
Okay, thank you. Sayon, do you have any observations here?
I basically share the view with Anu. I just add a little bit on that. When you look at the makeup of the member countries of BRITACOM, we can see it is quite different from that of OECD Global Forum. So other countries may consider joining the BRITACOM as a way to strengthen tax cooperation within members of BRITACOM. But at this moment, as Anu explained, it doesn't seem like EOI has been given a high priority by the BRITACOM. At present, its initiative is more or less targeted to other issues such as improving governance in international taxation or creating a more enabling environment for investment. In order for BRITACOM to function as an effective EOI network in the future, it is necessary to develop items that can intrigue member countries' shared interest and to mobilize the necessary resources to establish legal and technical system which will needed to support the EOI. Depending on how well BRITACOM deals with these issues, the impact of BRITACOM on EOI will drastically be changed. So it's better to follow up BRITACOM developments and see if there's any changes made. Back to you, Chair.
Thank you, Sayan. Well, that brings us pretty much to the end of our session. We've gone a couple of minutes over time. I don't think there are any questions. So with that, I'd like to thank my panelists. Thank you, Anu. Thank you, Sayon, Barbara, and Masato. I thought that was very enlightening and hopefully gives us food for thinking about what is going to happen in the future. So at this stage, let me hand over to Kuntal Dev. Kuntal, based in India, is the regional chair of IFA Asia Pacific. And Kuntal, could I leave it to you to make some closing remarks, please?
Yeah, sure. Thank you, Michael. I hope I am audible and you can see me well. Okay, fine. So, as a chair of Asia Pacific region committee, it's my pleasure to see that fantastic proceedings took place on 2 days, on today as well as on 27th of April. And, at such a short notice, Hong Kong branch has really made a fantastic scientific event. And in spite of the, in this lockdown in the past 1 year, there has been deluge of so many Zoom webinars and, so many opportunities for people to participate and attend. In spite of that, looking at the number of participants on Hong Kong branch webinar, I think I'm very happy. And I think it's a good decision which committee has taken in the recent past to hold Asia Pacific regional webinar once every quarter. So I think it's really turned out well. And let me therefore just formally thank all the participants of this webinar, as well as the speakers and panelists of this 2-day webinar event. It was without their support, I think this would have not been possible. And of course, Hong Kong branch office bearers, they have very well handled this webinar, and 3 main individuals behind Hong Kong branch, Michael, Stefano, and my friend from old good days of IFA Yin days, William. All 3 of you deserve a very hearty, appreciation. And, I clap on behalf of all of us. Thank you so much. And to all the participants, just for your information, we have next webinar on 3rd to 5th June which would be convened and hosted by India, which is for the quarter June. Similarly, we will have webinar for the quarter September to be hosted by Korea, and quarter December to be hosted by Japan. I'm really looking forward to all these upcoming webinars. And if you have any comments, any suggestions, and if you would like to get involved into IFA APAC region, please do reach out to us. Thank you, Michael, and back to you. Thank you, Michael.
Thank you, ladies and gentlemen. That concludes our session. Thank you for attending.
Thank you.
Thank you.